Welcome back to the House Judiciary Committee this Friday afternoon, May 9th. And I think we'll start with the witness, right? Yes, let's start with Heather McLean, who's going to address some questions that one of the members who's not sitting in the seat right now had, but we can get the questions. This is 109, the amendment to 2.1. It should have been a new version, should have dropped on your page. Yeah, right here. And I'm trying to find exactly where we're looking for. Oh, yeah, right. We're looking at section 25A and 25B. And actually, I think also, Ian, you had a question, didn't you?
I think I
I think,
did.
in fact, all sorts of questions. So I'll start with Barbara, then Ian can ask a question. I mean, unless you want to make a statement about this first, but I think, yeah. Okay, questions. Wow.
Thank you for coming.
Thanks for having me back.
So
Thank you.
I think one thing is just refreshing our memories because we knew that the language got taken out, but then it got put back in. I can tell you what my question was, which was when for abuse and neglect cases, DCF, someone from DCF had said that it isn't used anymore for making determinations. And that made me wonder about, because we were talking about can pay versus do they have the ability, like have they been paying versus the ability to pay? And I wondered about neglect, if somebody can't. So that was my question.
Yep.
And if you could identify yourself for the record as well.
Absolutely.
Thank you.
For the record, I'm Heather McLean. I'm the Revenue Enhancement Director for DCF Family Services. And so I think what would be helpful is just to clarify exactly the situation that we're talking about, which is what is the state compelling a parent to pay the state to offset the cost of foster care. So we're not talking about considerations of did the parent pay the other parent when the child was in the home, which I think speaks to what you're saying. But what we're talking about is when a child enters foster care, the state in the past has pursued child support on behalf of the state, and the parents then would pay child support to offset the cost of foster care. And that's what we're saying. We don't do that practice anymore. We believe it's not in the best interest of children and families to pursue child support in those situations. And therefore, because we're not doing that, we also want the TPR statute to match the practice, which is that then it's not considered. And I know one of the questions that came up yesterday when I was watching was related to, are we only asking that non-payment is considered? And we're actually saying we don't want payment or non-payment to be considered, that it should be completely, that we're not pursuing child support and considerations of child support paid to the state when a child is in foster care is completely divorced from the TPR matter at hand.
Okay, and you're only talking about, so is this language staying in place for determinations of abuse or neglect?
This doesn't change any other statute.
I think I'm done.
Yeah, go ahead.
Well, so that's not what this says then.
Right.
Yeah.
Yes. So I think what happened is we were trying to thread the needle so closely to stay in our lane that I think we created more confusion. And so I proposed actually some additional language that's being vetted right now that would really spell it out clearly that we're talking about payment or non-payment of child support to the state to offset the cost of foster care.
And that's the only thing, and that it would not be a factor in a TPR.
That's right.
Okay, that, if we can clarify, that makes a lot more sense. Because I have a lot to, if we're going down the TPR route, then I think, yeah, okay.
Wait, I'm confused, I think. Are you looking at the amendment language?
I think I'm looking at right here.
No, but hearing what the proposal is going to be.
If the proposal is going to clarify,
Clear to me in the, are you talking, sorry, Heather, are you talking about clarifying even further than what is offered in this amendment?
Yes, because the way it's written there, it's saying, it talks about failure to pay child support, but really what we're intending is that whether or not somebody pays child support is not a consideration. Because we don't want to set up a system. I think what your careful review of the language showed is that we could potentially be setting up a system where we're favoring families who have financial resources and can pay, even if we say, well, we're not going to hold it against you if you can't, it just is not, it's still a bifurcated system that isn't fair.
So why isn't it just simply the court shall not consider whether the parent made payments to the Department of Children and Families, or is that along the lines of the language?
It will be similar to that.
Okay, all right.
But keeping, because this to me was the department, payments to the Department of Children and Family for the Smart of Health. I feel like that was new, right? Did we have, that was that in the, as offered
Yes.
as amendment, that further clarification, that was clarifying the previous language.
That's correct.
Okay, and so you're going to clarify even
Yes.
further.
And the other point I will just mention is that we're going to further clarify that we're talking about Department for Children and Families, Family Services Division, because we don't want to make any changes that will impact Office of Child Support, which is also Department for Children and Families.
So I think now in that clarification of the clarification, I think I guess I'm still sort of having an issue with it. And I guess are we just kind of discussing this?
Yeah, go ahead. Yeah, go ahead. Yeah.
So I guess what I want to know, and you can just clarify, hopefully you can clarify
Sure.
for me. So TPR situation, I'm representing the party who's potentially going to lose their parental rights. Are we proposing that there would be language in there that I couldn't put evidence of payment of child support as evidence for the court for consideration as far as whether my client's parental rights should be terminated?
I am not sure I can answer that. I think what we're proposing is that the department would not, when they are creating their documentation stating the reasons that we're seeking a TPR, that child support would not be included. Child support paid to the department would not be included in those considerations.
So then I think then the proposed language that comes back needs to remove the court. Because I guess the language we have here is saying the court's not going to consider it. So I think that would make me see that any party that puts evidence forward, that evidence wouldn't be considered if it had to do with child support payments.
Okay.
Is that?
And is it true then, Heather, that what I think I hear you saying is that DCF wouldn't bring that forward anyway, so then the court wouldn't be asked to consider it.
Right.
In this very
Yes.
narrow set of cases and circumstances that you're talking about.
Right.
Right, so yeah, it would make sense to get rid of.
Yeah, I mean, if I'm understanding it, which I may not, that's kind of, because I think that was what we heard testimony about before we had DCF come in, which was like in other scenarios that DCF's not involved in, the discussion around payment of child support seems like an important element of including payment of it as like a sign that someone's engaged.
Right.
So, yeah, I think
Right. Yep. And I think that our position is that whether or not someone is paying or not paying the state to offset the cost of foster care isn't a determination of their fitness as a parent.
yeah.
There are a lot of reasons people may choose or not choose to pay, including that they are living in poverty and can't afford it, or
Yeah.
So are we in the right?
just.
You know what I mean? Like, it sounds like that's really a DCF thing. I just don't have, I have my lunch on top of my computer, a me problem, but maybe I would look to, and Eric, you didn't address this part, right?
No, this came from the department.
Right, so do you have 33 VSA 5317D memorized by any chance?
Nope.
Okay.
I don't have it memorized, but the reason that we thought that it fit in the TPR and adoption statute is because that is what governs us as well.
Okay,
Once we get to the point of TPR and
so
adoption.
it's the right place to
Right.
to make this very clear. Even if we take out the court. Okay.
So it's going to read something more like, I'm actually going to ask a question now. It's going to read something more like DCF shall not bring forward a petition with a basis of payment or non-payment of child support as that kind of thing. More.
It may.
It may. All right, cool.
Well, see, I think this is useful because I think
is.
for us certainly to get, like, I don't like the term drilling down, but like, we're really getting to the,
Yes.
exactly what the department is trying to address.
Yes.
Yeah. And you want to limit yourself to not, yeah, okay. Yeah. Go ahead, Barb.
So I just want to make sure that, so there may still be times, because we're not changing the other statute, when maybe they're trying to do a TPR or determine if if DCF is going to take a child into custody, when whatever the rationale is for a parent to not be paying child support may factor in because it may be relevant to neglect or abandonment.
Sure.
Okay, so
Yes.
that nothing's, yeah, okay.
Right. What we're really specifically talking about is when we pursue it as the department and the payment comes to the department, not past parental actions.
Yeah.
So I'm good.
Okay. Anybody else, good until we see the.
Thank you for coming back in.
Yeah. Thanks for having me.
Do you feel like this could have been an email?
Thank you.
I'm happy.
You missed all the free games
That's
now.
right. I just live up the road, so it's fine.
Thank you.
Excellent. Thank you very much for.
Thank you.
Thank you.
So we will send
Send it to Eric.
Eric
Yeah, that'd be
the
great.
proposed language. Great. Thank you.
Thank
you.
Eric, do you want to just join us and tell us about what else has changed, you know, just
Sure.
as far as the sixth instance of amendment, I guess? and,
Yep.
Seven now,
What's that?
or will it be seven now?
No, no.
That's in the second instance of it.
Yeah, that's still the new space.
Great.
Okay,
Sixth instance, which is on page 4.
okay.
Well, prior to that, Eric Fitzpatrick with the Office of Legislative Counsel here to, as the chair said, chat with the committee about the second draft of the amendment to S-109. There is one typographical fix that Representative Arsenault caught. You'll see page 1, line 18, 25B. There are no longer two 25As.
All right.
Another interesting point, well, I thought was interesting anyway. So this has been through the editorial process, and you'll see they kept line 3 of page 1, that it's the bill that's being amended, not the proposal of amendment. So my initial instinct was correct. I had to put that on the record, just. Although still, sometimes the House clerk for and Senate bills, the Senate clerk makes those corrections as well. So sometimes, who knows? It's still an open question, but we'll see how that introductory language ends up. Substantively, though, the changes are in, as the chair said, in the sixth instance of amendment, which begins on page 4. And that involved the child and parent legal representation task force. The real change is some language that's not there, but on right around lines 8 to 9, and this having to do with what the task force was supposed to study. You remember that was a relief from abuse orders issue that the committee discussed yesterday. And that had been in the list of issues that the task force was going to study, but that's been deleted. So it's only going to be looking at improved legal representation for children and families who are involved in judicial or administrative proceedings concerning chins or substantiations of abuse or neglect. Previously in that list had also been relief from abuse orders. Same change over on page 6. And that's lines 7 through 8. Also, it's exactly the same as the language you just looked at, talking about abuse and neglect proceedings and chins proceedings, and the relief from abuse proceedings have been struck. So they're not there anymore. Chief Justice is the chair. And I believe those were that wasn't, I think in the previous draft, you had already had can't recall if in the previous draft, I think you did, you already had the Attorney General and the Executive Director of State Senators and Sheriffs were already on the task force.
Yeah.
So. Other than that, I think it's the same as it was.
Any questions for Eric? So this is not being voted on, from what I understand, on appropriations this afternoon. So that means they'll be looking at it on Tuesday. So it will be on the notice calendar presumably on Wednesday. So this will give us time to look at this again on Tuesday, with the whatever we get back from DCF. So we'll schedule you for some, yeah, I would think, or Wednesday morning, one or the other.
Right.
So, and it's possible that, I don't know if we're at the stage, we'll maybe know better if we're at the stage where they'll be seeking, all the suspensions of rules to move things along.
Right.
And talk to those. I don't know if we're gonna be there at that point on Wednesday, but we'll know in advance certainly.
Sounds good.
Unlikely Wednesday, but it could be as early as Thursday.
Right.
On the floor. All right.
So if I happen to get the language from DCF, I can send it to you for circulation.
Yeah,
If that makes
right.
sense.
No, that makes sense.
Right.
All right. Perfect. Okay, thank you.
Thank you.
So Jessica, we're not doing H41 this afternoon, if that's what you're here for. And, it's gonna be on-
You didn't strike your.
Yeah, yeah, I apologize. I'm a little late on getting that change on the calendar, on the agenda. So where are people with S12, the ceiling bill? Are we ready to vote it this afternoon? People want the weekend to look at it and vote it on Tuesday? Yes, I'm trying to rush things, but don't want to rush things, but it's just that kind of timing at the end, because we want to get this out so that we can get the committee conference going. But does anybody need more time? Or are we ready to vote on
Remind me where we ended up with this
the same thing?
very quickly. Yeah.
We didn't, so the big change, we did not change any of the felonies. We didn't do anything with that. I explored that, but in part, because I wanted that on the record that that was a bad idea. And we have taken away some of the restrictions that were put on the use of sealed information by criminal justice agencies, which includes law enforcement, state's attorneys, the other entities on this.
Taking away the restriction.
Yeah, there were restrictions that you had to have a petition for access, and we eliminated that. There's still to use information court. There's now a process that we worked on today for the court to consider whether a sealed record can be used in open court or for public filing. That's the biggest change we did. We a couple other things with the exceptions are that we made clear who is responsible for discovery obligations, and that defense counsel can use the documents as well. The other big change is we put in there for deferred sentences. The current law says that the criminal record is expunged if somebody successfully completes their deferred sentence. We changed that to sealing. Those are the major changes that we've done on the bill. I'm pretty sure I caught most of the major changes. But again, we can vote it out on Tuesday if folks are uncomfortable doing it today.
As long as, I want to say it's fair and balanced as we can possibly get it set for now. And the big entity, as far as I'm concerned, which is public safety. In those situations can cover themselves. I think I'm okay with it.
Yeah, I
Were you comfortable with that? On your level? If you don't mind me asking.
No, I like it.
yeah, Department of State's attorneys and DPS both actually appreciated where we went with the bill from where it came up in the Senate as well.
Because in the end, we didn't stray that far from the Senate, right?
We strayed in a direction that I think allows in many of our witnesses' views, appropriate use of sealed records without barriers that didn't make much sense. We got rid of those. The other thing just to note for folks is the next step on this is, like I keep on saying, is committee of conference, because I already understand that almost certainly what they're going to request when this goes over the Senate is my understanding. Who knows, maybe they'll surprise me.
Why?
They'll just, because they don't like some of the things that we've done. So I can tell in advance. But my point is that going into committee of conference, if there's some additional issue, if somebody all of a sudden, like we had with 109, where at the very end or even after we passed it, a couple things came up. There's an opportunity in the committee of conference that if for some reason, and that's why I'm going to, Marshall Paul, I think this fixes what his issue was the other day. Not all of his issues. He still hates the bill and thinks it's horrible because of what we did with taking away the restrictions. But we did fix one of those main issues, having equivalent use by defense counsel as prosecutors can use it. Having said that, I'm gonna schedule him to weigh in on Tuesday afternoon, and if he has some issue, we can do an amendment actually even before it gets on the floor. But I just want to get this onto the calendar. It's kind of what dealing with the end of session calendar math.
I'm leaning towards I'm okay with it. I guess the best we're gonna get, and then it's gonna go to conference anyway, so. And then we're gonna make more adjustments and we're gonna have to, and all that stuff, so this is far from being over, probably. So I can,
You okay?
I mean, I personally would feel a lot more comfortable if we struck lines 3 through 6 on page 7.
could have warned me and get it out.
Yeah, and beyond that, I feel largely comfortable with the bill, but I do have concerns about 3 through 6.
On what page?
On S12,
What page? What page?
page 7.
What's the crimes?
That's a crime. So, because my thinking there is, say you are a financial institution and you hire someone who has embezzled and they choose to embezzle again. And yes, you can prosecute them for the second embezzlement. Are you going to wait for them to do that crime? I just think it's more of a character thing than I think it provides unnecessary risk for financial institutions to take on for someone who has committed embezzlement from the firm.
Right.
I think that's pretty black and white.
I mean, where are people with?
I would agree with that.
Yeah,
That's the one spot I'm sticking with this, yeah. I forgot about that.
Okay.
They would, well,
Karen?
Yeah, I would like to leave it. We haven't received any data that says that that is the case. And so,
Excluding from states that.
I mean, if we want to bring in witnesses, I'm happy to line people up,
oh, we had a witness in.
but someone that would be supportive of this. I mean, like this
That
seems,
has data.
this seems pretty flagrant to me. And I think like my thing's this, Chair,
Yeah, no.
is when you look at retail theft, I get like if in a moment of desperation, if someone makes a mistake and they steal something, I understand that. Embezzlement, there's a certain level of intent there.
Right.
That you're looking to obfuscate and materially impact organizations. I mean, granted, maybe it's because of the world that I've been in and living in for the last decade of my career, but I guess it may be a different perspective than others, but that seems a pretty serious infraction.
And 7 years.
embezzlement is what usually,
It's the clean copy, the bill.
yeah, are these the
Thank you.
non-violent felony?
No, nonviolent felonies would include.
But isn't embezzlement a felony?
Yeah, these are the property felonies. So
So that would be a non-violent felony?
it is a nonviolent felony.
But not all nonviolent felonies are on the list.
Right.
And when did these get put in?
From day one.
From day one?
Yeah, last year and pursuant to the Sentencing Commission's recommendations, is my understanding.
That's usually,
Yeah, it's heavy.
did, the bankers, I can't think of his name.
Chris.
Yeah, Chris.
Yeah,
Did
did he testify on that? Yeah, he didn't want those.
He didn't want.
Yeah, he didn't want those.
Or he wanted it moved to a 10-year,
That's, yeah.
which if we were going to compromise, I could do that, but there's no data on that.
And we had Morgan Stanley in a few years ago who supported.
Well, I can tell you, Barbara,
expungement.
a wealth management advisor from Morgan Stanley, Vermont, it's very different than a large scale financial
It
institution.
was somebody from New York.
Okay. Well, I mean, what division of Morgan Stanley were they in?
I'm
I
gonna
wasn't
look up
there.
who
Yeah.
testified.
So,
Oh, Ian has his hand up.
yeah,
Oh, if you want to go.
no, go ahead. I'm thinking still.
I think just bringing the perspective of someone who wasn't here last year. So I didn't hear any of the testimony about how any of these were included. Cutting out stuff at the last minute for maybe reasonable things. I think you could take Zach's argument and apply it to literally every single one of the things under the property designated felony property offenses. You know, forgery and counterfeiting is an intent crime. Uttering a forged or counterfeit instrument also. If we want to start thinking about cutting stuff out, I'd like to sort of hear how we decided on which ones are in.
Yeah.
But given the fact that these, after all the testimony last year, these landed in, it makes me think that they should stay based on whatever the conversation and the rationale for it last time around.
Unless we completely missed it altogether.
Well, I have deep faith in the intelligence of the judiciary.
Well, I mean, like, you know, as Ian said, like, we weren't privy to that testimony,
Right.
having not been here last year. I mean, I'm happy to look back on the tape and see what the justifications are, but I'm telling the body that's presently assembled here that I have concerns about that.
So let me ask you, so Chris Delia, one of the options was to go to a 10-year. Would that satisfy you or do you still?
Can I have the weekend to speak with Chris?
So, yeah, I mean, the other option, I mean, if we want to get this onto. We want to get this onto the calendar and keep it moving, you can bring an amendment to strike.
I don't
those.
want to do an amendment.
So yeah, we'll vote it on Tuesday.
Great.
Yeah, that's fine. And look into that. All right, so let's,
Well, okay.
yeah, I mean, I mean, my point, I wasn't gonna rush.
Testified and it's recorded. I don't know.
Yes, yeah, Chris did testify. I mean, I don't know if you were here for the testimony or not. Chris's.
I'm not recalling it. So
Okay, yeah.
It
yeah,
was
yeah.
this
So-
week or last
So
week.
yeah, he did testify.
Like, just recently.
Didn't he say he'd prefer to have it pulled, but he could live with 10 years?
He preferred to have an exemption, not to pull it. Actually, he never is.
No, he said he wasn't gonna suggest that even because that one kind of raises who else is gonna want more. of these.
Exactly, exemptions though. So he was always keeping it in. He was always keeping these as ones that could be sealed, just who is exempt from getting to
And
see it.
this was a subset of what he suggested,
Yeah.
although I think he was going broader, and I agree that of all of these crimes, Zach is the ones that.
it's really those three.
When
I'm
had
fine with
most-
everything else being included.
Yeah, but had most concerns last biennium as well.
Okay.
So I mean, it's, so we should, look at that a little bit further and personally, as a compromise on this, when I heard the issues from Chris, and Chris has been very good on these issues, I was willing to entertain that, if other folks were. So, but we have the weekend to think about this. All right, so that's fine. No, you gotta push for things and understand that you're probably not gonna get there on as far as timing and stuff, because we're not running out of time yet. Just getting,
I'd rather get it right.
Yeah.
than rush something out.
well, no, me too. So we'll do H98 then, and all I need on this one is this discussion and straw poll. So H98, the confirmatory adoption, but also has the new provisions related to consensual standby guardianship. do people want to weigh in, or should I get a motion on the table?
Which one, H89?
H98,
H98, sorry, 9889.
the one you don't like.
No, I don't like it.
So
Which one is this?
H98 is a confirmatory adoption as a standby.
Oh, yeah, I'm built the standby guardianship part.
Right, no, yeah, understood. Yeah, we can talk about this, yeah.
Yeah, I mean, you probably know where I stand on this, but I guess to state it out loud, I just have really severe reservations about creating any kind of provision that would allow for the state and our laws to be manipulated, monopolized, by people looking to do harm that are coming to the state, and potentially leaving their children here and creating and adding to what is already a really catastrophic situation across this country and making it even worse. And I think it's a real shame because when the bill left this committee to go over to the Senate, I was extremely supportive of it. Having, friends and family members and Vermonters that would benefit from all the great things that this committee wanted to do in the original legislation. I just think it is people taking the current political environment and looking for any kind of instance to antagonize and to provoke. And I really am beyond frustrated with that. I think it's quite shameful. And I think it's a shame that, and it's sad to me that a really good piece of legislation is being weaponized in this way. It bothers me.
Well, on top of that, when reading ICE's policy, they do the exact same thing that we're looking to do here. They will try to find a guardian at all costs before they have to go to DCF. And that's how it's done. And they frequently will sacrifice keeping one parent with that child as well. They do everything humanly possible to avoid the situation of putting a kid into DCF custody. And to duplicate their efforts and the state's efforts at the same time, I don't know what kind of problems that could cause, but we're jumping into their lane when it's something they already do. I know for a fact that they tried very hard at it. I've witnessed it.
So
I've got.
So I guess,
We already have a system that will take the kid when it gets to the point that somebody has to watch it.
Yeah, the system is DCF, and that's something I want to avoid. And the fact that I've heard from, we've heard from DCF testifying in favor of this, that the fact that this is a backstop. I mean, if it falls through the cracks with ICE, rather than this kid going to DCF and all the issues that creates as far as reuniting the kid.
That's exactly what I'm talking about. If DCF can't find guardianship, then the kid's gonna go into DCF custody.
So this is allowing the individuals in advance of an adverse immigration situation where they are no longer available because they're in custody, to have something set up so that somebody that knows the kid, that knows the family, that has consented to being the guardian, can become the guardian. And
Did you read the ICE policy?
I have the ICE policy.
Well, yeah, I think you need to read it because they'll do that.
Well,
At any time, or they will not deport somebody or put them in an adverse ICE situation if there are children there in a civil adverse immigration issue.
So I also look even at the fact of the last witness that we had, that they have the paperwork set up. They haven't gotten all the way through to the guardianship because they haven't needed to, and the individuals were going to check in. And they went to where that guardian, the person would become the guardian if, for whatever reason, the paperwork wasn't right and they were taken away, that they were with family friend, somebody that's consented to it. I just don't see.
And that brings to me the other point. What happened? Nothing. And we haven't had an instance of this happen yet.
Yeah, but
So
this is preemptory.
It's very preemptive, but why wouldn't it have happened yet? We do deportations all the time out of the state of Vermont. It doesn't make sense to legislate something that doesn't need legislating. It's not happening. It's not an issue. It's great, and I understand, and I understand the point, and I totally feel for the families. But We don't need a backstop. We would have hit it already.
Well, I mean, I understand, but it seems
Okay.
like
I'll
a
just-
fairly straightforward thing to
I
do.
know.
And,
Okay.
and a lot of witnesses, a lot of people have really want this. Not that it matters, it passed out.
It
of
sounds good,
Senate
but if you don't know the
Judiciary.
whole history and you didn't read the ICE policy, and
I-
we've heard from everybody
Can we
on the
not
other side.
interrupt each
We've
other?
heard from everybody on one side, not the ICE side whatsoever. And I think we owe the responsibility to understand the ICE side. Whether you hear from them or not, you can at least read their policy. They don't leave kids abandoned.
No, I hope not.
And they always try to put them with like-minded people. That's their first choice, if you read their policy.
Yeah, Mark.
So
Family is first in their policy.
the reason that I think this bill is important is not because I think ICE is not doing their job. I think parents having control over where their kids go, no matter who the parents are or what the situation, is preferable than having a government agency deciding where somebody's children should
But
go.
that's what I'm trying to say. They don't. They try to give the parent the option to do that.
Please, interrupting.
Well, some people need to read it and educate themselves on what actually is set up to happen.
I'm just talking about the interruption though. It's just,
Yeah, you're right.
So if a family is anxious, whether or not they should be anxious because it's going to happen, having a plan in place and being able to talk to their child about the plan is very important. And whether or not we like it, I think it's harder sometimes when it's somebody from the feds or the state that's having those conversations to recruit than it is to have somebody who's like, you know, a peer, like somebody who went to church with them, like saying, if anything ever happens to my kid, could somebody step in? I totally got your concern yesterday about like making sure that people aren't trafficking. And I think we need to make sure that we're keeping kids safe, and maybe it's DCF checking in with the families in this situation once, if and when this happens, so that kids have an extra set of eyes keeping them safe, given that they're not going through a home study process. But it's a very different feel, and it doesn't feel like it goes against what ICE's policy is. I mean,
It's the same as their policy and they're willing to do it.
right, but they probably have lots of things to do too. And I don't get why it would be a problem other than the worry about the trafficking, but which again, there is probably a way to make sure
Well, we
there's some
better
extra
get that part
checks and
right.
balances.
I don't know why a previous administration deported 3 million people before this one. And all of a sudden, we're worried about this. 3 million people. And now and it didn't happen, or if it did, we didn't do anything about it, but now we're worried about it.
I do know that we are looking to expand greatly detention center options. And there is an ask to greatly increase the appropriation for ICE in Congress, going to Congress now, because there is a more extensive effort underway we heard the ag commissioner on the news today talk about his worry about more people getting, more farmhands getting deported.
Are we
Yeah.
just continuing discussion or? I don't have any more. I'm ready to take a straw poll. I don't know if we're gonna persuade anybody else anymore, like.
well, I do want to say that I see some different, I don't know if I'm reading the right thing, Tom, but when I look at the ICE detained parents directive, I see a difference in the two approaches because what's proposed in H98 is proactive. And like Barbara's saying, it's allowing that, it's that opportunity for parents to decide and to even have that conversation with their kids, and that things aren't happening in a really, what I can imagine as a really chaotic, highly emotional moment. So I'm thinking about the kids. I think it's great for the parents too, but I'm thinking about the kids and what we know about childhood trauma, and being separated from your parent is going to be traumatic, but this might be one of the few ways we have to reduce that trauma, to mitigate that trauma. Yeah, so, and as for, I did hear that there's a need, knowing that DCF wants this, knowing that the folks who are working with folks who are undocumented or of varying statuses, knowing that they are advocating for it and saying there is a need. I don't feel that I'm in a position sitting here in this room to, certainly for me to say whether there's an immediate need or not. But for all the reasons that we heard in testimony, and again, for that proactive step, I think it's really important. And I think what's sad is that this would be necessary at all. Not that we're trying to do something about it.
It's not necessary.
That's the point.
Exactly.
That's the whole point.
It's great
I mean,
that
what's better than in the moment?
that you feel that way. It really is.
It's the
It tells me
reality.
that you have faith in
I do.
certain institutions,
happen.
and that's a really great position to be in. And there are millions of people in our country who are not in that position. And so I'm mindful of their position, and that it would be wonderful if we could all have that faith. I'm not at all being facetious. That's like an ideal situation. It's just not the situation we live in.
DCF is there as a backup. If there is no way to set up a guardian, and what
Right,
better at the
right.
moment of the stop when they're there with the kids, the parents can tell ICE, I want my kids to be with this person, and it's a done deal.
Right, and the testimony we heard, which for me was extremely compelling, from the, Vermonter who's been helping folks in this position, and his description of the parents' relief, if that's the right word, or relative peace, just knowing that they could explain to their child what may happen.
That wouldn't change that scenario whatsoever.
Well,
Okay, I think it changes it quite a bit.
How? They would not have removed the parents and not done nothing with the kid.
Yeah, I think still having the piece of doing it
Okay. Let's
beforehand
just go.
for me is.
Yeah, I don't know
Yeah.
if this is gonna be productive
yeah,
conversation.
No, it's not.
No, I think, yeah, I think we've moved enough on this. So I will take the motion to concur with H98. And is there a second?
Second,
It's just a straw poll is all, yeah, so it's straw poll. All those in favor of concurring with H98, please raise their hand. Those who do not concur, raise your hand. Right now it's 5-3. Because it is a straw poll, I'll reach out to Alicia, Tom,
Is Coach online?
and Coach. He was, but I'll reach out to the three of them by Wednesday or Tuesday, because this will be on the floor on Tuesday. All right, thank you for the discussion. I understand where people are on, there's different views, yeah. So we just did a straw poll on H98. Tom, it's currently 5-3. If you want to weigh in, or you can weigh in after talking to folks because you weren't here for the discussion.
Yeah.
Oh, yeah, okay, that's fine. Yeah, I just need an answer by Tuesday, really, but when it's.
I think one last thing though, Martin, like it doesn't even seem like there's an effort on one side to even try to arrive at a compromise. And it just is a flagrant disregard for the concerns that someone who is a subject matter expert and knows people in the field is presenting to the committee for their consideration.
And also.
And that's, hold on a second, Barbara, we're talking about interrupting. Give me a break. I'm not finished my point here.
So
But we're talking about, we're being lectured about interrupting. It's constant, interrupt. And then Barbara does it. It's like, give me an ever-loving break, Angela.
So
I didn't even say anything. It's the look. Look at your, I mean, just look at your facial expression. It's just, it's just give me a break.
Just air it out, dude.
It's just so nasty. It's so nasty.
all right.
And
So-
Tom is presenting these concerns from a very informed perspective. And
Just
We had
Why?
witnesses. We had witnesses
That's-
with a very informed perspective.
But Angela, we only heard from one side of the issue. That's the whole point of the concern that we're trying to present here. We didn't have anyone from ICE. We didn't have anyone from Border Patrol. We didn't have anyone from law enforcement. We didn't have any of the practitioners of the policy that you're trying to craft in the room to advise you. And you wouldn't care either way.
No,
It
I
doesn't-
do. They're not the same policy
And-
though.
Angela, you've been here, right? And so if this is such a great concern, to Tom's point, we had 3 million people deported from the country last year under the last administration. Why didn't this legislation come up last year? Why
There
not?
are hundreds of pieces of legislation that do or do not come up every year.
Why
that we
not?
don't
If it's
get
such a big
to.
concern.
It's an emerging concern.
I just think it's fear mongering and it's totally sensationalized. Is what it is.
That's your perspective and that's
And you
fine.
have yours.
Right.
Yes.
And I.
But I just think the disregard of a viewpoint in the room, Chair.
I don't-
I'd like to give the chair the
Karen,
floor.
please.
Yeah, no. So I mean, I don't think there's disregard. If there were proposals as far as what to do, we could consider them, or we still can consider them if somebody wanted to try to bring an amendment to this. But I don't think that's where we were. It's the underlying question is whether we need this at all because ICE is doing fine, or is this a good backstop?
Well, we have no
And
instances
so-
of it happening, so it seems like it's working.
So yeah, maybe in Vermont, if I recall, on the last administration, there were hundreds of kids that were displaced from their parents and were being held in detention cells down the border. So it's like, could this kind of stuff happen? Yeah, I think it could.
Well, when you allow
I hope
18
that
million
doesn't.
people in, when you allow 18 million people in the country illegally,
So-
then yes, it does happen.
Well, so
Absolutely.
this can happen. I hope that
For
it's
sure.
never having to be used. I hope that ICE does what they're supposed to do and takes care of the children. But if they don't, if something falls through the cracks, then this is there. It is also there for the parents' peace of mind. So I mean, that seems pretty straightforward to me. So in any event, with that, we still need to get a vote from 3 individuals, but it's on the calendar, and it will be up for action on Tuesday afternoon. So I think that's it. We will meet, I was thinking we may have to meet before floor on Tuesday, but I don't think so. I think we've covered what we can cover today, but we'll try to get the vote out on S12 on Tuesday. All right, we're adjourned.